Not sure if my time begins with the pleasantries, but I want to welcome you to the court and thank you for your statements here. My name is Cathie Viens. I'm in Precinct 4. This courtroom is not only the place where citizens have the opportunity to address the topics you vote on, but also to address matters of interest not listed on the agenda. It is virtually the only place where we, the people, can meet with all of you at the same time. At the public comment period, we pose questions, make objections, offer ideas, and inform you of issues that concern us. The Open Meetings Act discourages conversation at this point, but does not prevent the court from correcting misstatements of fact. On the other hand, during discussion on an agenda item, the Open Meetings Act does allow for the court to respond to questions posed at this podium. This provides the opportunity to foster transparency and accountability. Yet members of the court continue to denigrate speakers at this podium by minimizing that opportunity for interaction as, quote, the back and forth. The back and forth is the conversation. It's your chance to reveal your perspective and to understand ours. By cutting those back and forths, what you reveal is your determination to separate yourselves from the citizens in this court. By minimizing or avoiding conversation when voting on an agenda item, you give the appearance of not knowing the subject matter of your vote. When asked to articulate your vote on agenda items, a county employee is generally called up to testify. That's merely an explanation of the matter at hand. It's not your explanation of your yay or nay vote. That gives the appearance that the vote here is a rubber stamp. It does not inspire confidence that the members of this court are actually thinking and forming an opinion before the vote takes place. When the court heard the recent presentation by John Polster, there was the perfect opportunity for the court to take a turn asking questions on behalf of the people. Prior to and after that presentation, there have been questions raised by citizens regarding this arguably most controversial subject, the East Loop. When given the opportunity to ask questions, not one single question was asked. Is that what you promised your constituents when you ran for office? Last week, 3 citizens, Ms. Cindy Wiley, myself, and Dr. Walter Dougherty, a nationally renowned election integrity expert, addressed this court with questions and presented facts regarding imminent changes to the upcoming election. We were each given 4 minutes. No member of this court made a correction regarding any misstatement of fact. Immediately afterward, a presentation was made by a county employee whose time was not limited. No opportunity was given, as is typical on an agenda presentation, for the public to ask questions. The presenter was permitted to make the accusation that, quote, others who come before this court bring half-truths and spin things to fit their own agenda. Did any one of you question that comment? To whom was she referring? To Dr. Dougherty? To me? To Ms. Wiley? And what agenda do we have, other than the same one she has, to ensure safe, fair, transparent, accurate, and auditable elections? The rules of decorum on the back of the agenda stipulate that the court will not permit a member of the public to insult a member of the court. Should not the court protect the public from insults the same way it protects itself? The court has put itself in the position of being unfriendly, unresponsive, oppositional, elected body. Sadly, not an advocate or friend of the people. Thank you. And I brought copies.
Thank you, Cathie.